You know that feeling of being David facing Goliath? That's exactly what it's like when a huge debt collector comes knocking. It feels like they've got all the power, all the lawyers, and all you've got is, well, a slingshot. But what if I told you the rulebook for this game has completely changed? What if David now has a secret playbook that Goliath never, ever saw coming? Let's dive in.
It all starts with something like this. This sentence right here, buried deep in the fine print of some agreement you probably clicked yes to without a second thought. It basically says, if we have a problem, we're not going to a real court, we're going to something called arbitration. And for years, that was the company's home field advantage. But that's not the case anymore.
So the problem becomes very real the day a thick envelope lands in your mailbox. And nope, it's not a coupon. It's a lawsuit. A formal complaint has been filed against you in court. That company you used to buy stuff from, they're now your legal opponent, and the fight is officially on.
This slide just nails the difference between what it feels like and what it is. On the left, you see this terrifying stack of legalese and threats, and it's absolutely designed to intimidate you. But the reality is, what's on the right? It's just the start of a process with a set of rules. And here's the secret. If you know the rules, you can play the game.
Here's a perfect picture of it. On one side, you've got this raw, scary-looking legal document. It's confusing, it's blank, it's awful. But on the other side, you've got a guide that just breaks it all down step by step. All that complexity, it's really just a code. And once you have the key, you can suddenly see a way through the maze.
So, the fight is on. But the first big question is, where is this fight going to happen? Is it going to be in a public courtroom for all to see, or a private boardroom in arbitration? You better believe companies have a preference, and the battle over where you fight can turn into a whole war by itself.
Okay, just look at this real-world example, the Khadijah Smith case. It starts with a simple credit card back in 2013. 5 years later, boom, she gets sued. But then she fights back. And for the next 2 years, look at this timeline. The fight wasn't even about the debt itself. It was just about whether the case should be in court or arbitration. The company fought tooth and nail to get into arbitration. That tells you they think it's their turf. But what happens when consumers learn how to use those arbitration rules against them?
And that brings us to the good part, the consumer's secret playbook, because this is where the entire game gets flipped on its head. Thanks to some new rules from places like the American Arbitration Association, the playbook isn't so one-sided anymore. Consumers now have some seriously powerful plays of their own.
First play you can run, the 90-day stay. And this is it's brilliant. Let's say you're in court and the company tries to drag you into arbitration. The second you file a motion about that, the arbitration itself gets automatically paused for 90 days. Just like that. It gives you time to breathe, time to plan. It takes all the immediate pressure off.
Next up, you get the home field advantage. It used to be you might have to fly across the state for some in-person hearing. Not anymore. The new default is a virtual hearing. This is huge. No travel costs, and getting witnesses to show up is suddenly super easy. All they need is a Zoom link.
Now this one is a massive game changer. See their hand. The new rules make it crystal clear that you can demand their evidence. We're talking depositions, where you get to question their people. We're talking about making them produce every single document. You can force them to prove they even own the debt. They can't hide their cards from you anymore.
And this might be the most important play in the whole book, make them swear to it. See, under the old rules, it was kind of up to the arbitrator whether witnesses had to testify under oath. Not anymore. Now, if you request it, they must be sworn in. This means they're now liable for perjury and is a huge blow to that whole practice of robo-signing, where some employee just signs thousands of affidavits without even looking at them.
Okay, so you've used the new rules, you're in arbitration, and you're holding your own. But there's one more move, a move that is so powerful it can end the game right then and there and put all the pressure right back on Goliath.
I want you to remember this number, 30. That's how many days a company has to pay its side of the arbitration fees after the invoice is due. See, to get this whole process started, the company that wrote the contract, they're the ones who have to pay up first. And if they don't pay on time, they have just made a colossal mistake. And this failure to pay, it's not just like a late fee on your phone bill. The law actually defines it as a material breach of the whole arbitration agreement. You can think of it like this. They insisted you play the game in their stadium, by their special rules, and then they refused to pay to turn the lights on. Well, the law says that means they just forfeited the game.
So what happens when they commit this material breach? Well, the power shifts entirely to you. You get to decide what happens next. And look at these options. They are all fantastic for you. You can just withdraw from arbitration and drag them right back to court, the one place they were trying to avoid. Or you can stay in arbitration and force the arbitrator to punish them. You're in the driver's seat.
And if you do choose to go back to court, oh, the payoff is huge. The law is very, very clear. The company must pay for your lawyer and your court costs for all the trouble they caused. The court can slap them with even more sanctions on top of that. And best of all, you're free from the arbitration process they tried to trap you in. You've completely and totally flipped the script.
You see how this changes everything? That whole process, the one that was specifically designed to give companies an advantage, it now has all these trapdoors that can actually benefit you, the consumer. It is no longer an automatic win for the biggest player on the field.
So what this all boils down to is pretty simple. That system that feels so scary and so stacked against you, it's still a system with rules. And those rules, they apply to everybody, whether you're a giant corporation or just one person. By knowing the playbook, you can force Goliath to play by the very same rules he wrote.
You know, this isn't really just about debt collection. It's about realizing that even in these incredibly lopsided fights, knowing the rules is power. The game might feel rigged, but now you know some of the secret moves. So the only question left is, how would you decide to play?